All rise.
Please be seated. We will hear argument in 230955, Walgreens versus McKenzie.
May it please the court, Mr. Griffith will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court, good morning. Justices, O'Connor's Texas Civil Practice and Remedies Code Manual 2024-2025 states on page 137 that the Court of Appeals opinion in this case stands for the proposition that acts of hiring, training, and supervision are conduct, not communications. Our position is that is textbook bad law. It's literally textbook bad law and should be reversed by you. We ask you today to reaffirm what you taught us 30 years ago in the Byrd versus WCW case and back in 2012 in the Wannsee case, which is that to prevail on a claim for negligent hiring, training, or supervision, the plaintiff must establish not only that the employer was negligent in hiring, but also that the employee committed an actionable tort against the plaintiff. As Justice Wilson said in his dissent, that's because what he called the three theories, I'm going to use that today to be brief, the three theories are derivative torts. They derive from an underlying allegedly tortious act of the employee and are dependent on such a finding in order to prevail on that cause of action.
So we framed that slightly differently in our case in 2019, Endeavor versus Cuevas. I don't know if you're familiar with it, but there's there it dealt with a negligent hiring claim, and it said there are basically two separate acts of negligence. If there's the negligence in hiring, and then there's the employee's negligent act or omission, and that both negligent acts are required. And so is that a different way of saying the same thing that you're saying?
I hope not, because what you said is exactly what I am saying. It's the legal action that you're looking at. The legal action of negligent hiring has two prongs. Number one, the allegedly negligent act of hiring, training, or supervision, and the underlying employee tort. And I understand this case is being discussed today with the backdrop of Warner Enterprises. I tend to kind of agree with Justice Bland what you said in the Warner arguments, which is that, you know, essentially the act of negligent hiring, it's really just conduct or facts that inform what ultimately happened with the employee. So you have said that derivative torts, specifically conspiracy, are liability spreading theories that depend on liability for an underlying tort and survive or fail alongside that tort. That's the Agar case, 580 Southwest 3rd, 136. Further, and more importantly, you have either affirmed or denied petition in no less than 5 TCPA cases in which the Court of Appeals held that courts are not to analyze derivative torts.
But we're not bound by that.
Absolutely.
Right.
And my problem here, Justice, is that all of the cases I've seen are conspiracy cases. I have not seen one yet that dealt with this particular situation with respect to negligent hiring, but you've said that conspiracy is also a derivative tort.
You mentioned that we've either affirmed or denied the petition in several cases. There's a big difference between those two outcomes, wouldn't you say?
Absolutely, I agree. And again,
Just want to clarify that for the law student audience that we have.
Sure, yeah, but affirmed, like for instance, in the Comcast versus Baseball Partners case, the issue of conspiracy and derivative tort was brought to bear in that. And Mr. Chief Justice, I think that you joined a dissent with Justice Heck in that case, in which you at least briefly touched on this issue. I think Justice Heck's case just as a side note, said that because liability for civil conspiracy depends on participation in some underlying tort, the conspiracy claim should have been dismissed as well. We've also got the two Alex Jones InfoWar cases out of Austin that are a little more recent cases where at least the Court of Appeals dealt head on with this derivative and theory, the Dallas Cowboy case, Jones versus Posner, Warner Brothers. In other non-TCPA cases, at least one I found, you have held that courts are not to analyze a refusal to dismiss derivative claims separately from the refusal to dismiss underlying causes of action.
Let me ask you about the test that courts should apply here, because the question is the suit based on or in response to one of these protected rights? So what should we say, what's the right test for based on or in response to? The courts of appeals seem to have described it differently. Some talk about a nexus or a gravamen test or factual predicate. We said in Endeavor it depends in part on proof of. What should we tell lower courts to be looking for in deciding what based on or in response to freedom of free speech or any of the other protected rights?
You know, I see three different ways for the court to approach this. Number one is to simply revert to prior law to say, look, if it's as a common law principle, you've got a derivative theory. Once the protected conduct is found, derivative theories are shelved also, just as the Court of Appeals did with the respondent superior claim here. We say the exact same thing should have been done to negligent hiring. Choice number two, I think more closely to what you are asking, is as follows, and let me make sure I get my language correct. So the TCPA right is there if the legal action is based on or in response to a party's exercise of the right. So we start there. So we have to look at the legal action. The legal action of negligent hiring, training, and supervision is just like any other tort. It's a multi-pronged tort. Number one, you have to find the underlying alleged act of negligent hiring. Number two, you have to find that the employee committed an actionable tort. So I think the test would probably be that, of course, the negligent hiring legal action is based on or in response to the party's exercise of the right, because in order to find negligent hiring, in order to recover for a negligent hiring claim, you must prove that the employee committed the tort, which the defendant says is the protected act. So to me...
So would you say that it has to be an element of the claim, or it just happens to be an element of the claim here and that meets the test?
Well,
because we got to write with other cases in mind too.
Well, I'm not quite sure I understand. I mean, yes, it's certainly an element. I mean,
right, here it is, yeah. It
has to be proven. Conspiracy is a little bit different because that may or may not be an employee that did the underlying tort. But yes, here, by definition, the negligent hiring legal action is based on an act that the defendant will necessarily say was a protected act, as it was here.
So let me ask you about sort of factually how that applies here, because one of the arguments that Ms. McKenzie makes is that there were really two different torts that she's complaining about here. One was calling police, and the other one was the accusation in the store that she was a shoplifter in front of the other customers in the store. And one of those, her argument is, one of those is may be protected, calling the police, but the other one, just pointing you out in the store and in front of the other customers saying you're a crook, is not. And so what's your response to that?
Well, my response to that, I believe that was in the affidavit. Frankly, I'm not positive that was in the affidavit.
It is.
I know she briefed that. That was not in the pleading. That was not in the petition.
Well, the petition mentions being humiliated in front of other customers, so why isn't that enough to raise that issue?
To raise the issue
of that one of the things she's suing about is accusing her of being falsely of being a thief in front of the other people in the store.
Mm-hmm. Right. So, I would just revert back to Rule 45 and the fact that in this case, as Justice Wilson pointed out in the dissent, we challenged all of the causes of action.
Well, okay, so explain to me how, if all we had here was accusing her in front of other people in the store falsely of being a thief, and there were no police report. How does that fall under the TCPA?
An accusation, it still seems to me, would be a protected speech to accuse somebody of criminal conduct. I believe that's still First Amendment. I believe that's still, I think we're getting caught up on who the recipient of the communication is. I'm just not sure that would be an issue here. But again, you know.
Well, what's tricky here is you don't win on the TCPA by showing that the claim involves a protected act. You win by, you get the TCPA to apply by showing it's a protected act, and then you win if they can't make a prima facie showing, right? Is there any dispute here about whether they were able to make, here in this court, about whether they were able to make a prima facie showing?
Well, they did not make a prima facie showing.
And do they claim now in this court that they did?
I
mean, or did they claim that in the Court of Appeal? Because what the Court of Appeals said is negligence and intentional infliction should have been dismissed because TCPA applies, i.e. it involves speech, and they failed to make and Ms. McKenzie failed to make a prima facie showing, right?
Right.
And now in this court, nobody's arguing that they did make a prima facie showing, right? We're only now looking at the negligent hiring question.
I understand. That's correct. I don't think that became an issue. In other words, the Court of Appeals did part one and said protective conduct, these causes of action over here, respondeat superior goes over here. They should have said that with respect to negligent hiring. But at that point, yes, the burden would have been on her to come forward with clear and specific evidence showing a prima facie showing of those torts she alleged in her petition, which were negligent, intentional infliction.
Right, but the trial court denied the dismissal as to all claims.
As to all.
For the Court of Appeals to have then reversed and said, no, these two claims, intentional infliction and negligence, should be dismissed, the Court of Appeals had to have concluded not only that the TCPA applies, but also that she failed to make a prima facie showing as to those claims.
Correct.
Right?
Correct.
And the Court of Appeals did that.
They did that, but they did more. They did this act of what we say was engrafting unpleaded causes of action into the petition, and also I think attempted to buttress their ruling on that. And I've got strong feelings about that, which we put into the brief. But yes, the Court of Appeals definitely did step one, step two analysis, and the way they did it was strange because they said, all right, there was no prima facie showing as to an intentional infliction and negligence, but not as to negligent hiring.
Right, and then that gets to the issue you've brought to us, which is if there's no prima facie showing of negligence on the part of the employee, then as a matter of law, there can be no liability for negligent hiring on the part of the employer. Right, that's Forefront and Endeavor.
Correct,
right?
And exactly what the Court of Appeals did with respondeat superior. I think, respectfully, where they walked into error was after finding the employee conduct protected, still going ahead and doing an independent analysis of the negligent hiring claim, which under the test, we think is the test, that independent analysis should have never been done because in doing the independent analysis, they got into this thing about, well, was it conduct? Is it communications? Did it happen before the employee tort? And to do that, they created a precedent that in our mind, I don't think it's exaggeration, eviscerates the TCPA for employer defendants who are being sued for acts of negligent hiring.
Could I come back to Justice Busby's question here? I want to make sure that I understand the facts as we have them before our court today, and then get your view on what the legal significance is. So your friend in opposition on page 11 of the brief says that it was only, the police were only called after the Walgreens employee had, I guess, raised a hue and cry, had accused Miss McKenzie of being a thief, and then after committing the tort, the Walgreens employee then called the police. Do I have those facts correctly on the facts as we have them before us? And then what is the legal significance to Justice Busby's point of the petitioning your government calling law enforcement to the store happened only after the employee is alleged to have humiliated Miss McKenzie in front of a bunch of members of her community in a Walgreens?
So I believe we're reading more into that was made. Those points were made at the Court of Appeals level and in the briefing level. They simply weren't pleaded. And yes, so what I think is happening here is that, you know, the court is definitely supposed to conduct a holistic review of the pleadings and affidavits to see if the TCPA applies, but I think what happened here was that they essentially looked at the petition and the affidavit and grafted things onto the petition that weren't pleaded by her and then used that. So our
If we
point,
disagree with you about that and think that the petition mentions being humiliated in front of other customers, what then?
but it's not specific as to whether she was, okay, so the petition is not clear as to whether she was humiliated by other customers because of this alleged detention, questioning with the police, or prior conduct. I agree.
Did you file special exceptions?
We did not file special exceptions because the causes of action were clearly stated in the petition: intentional infliction, negligence. So we relied on Rule 45 and Rule 47, and we relied upon your opinions in Montelongo to say, look, the pleadings in the TCPA context are the best judge of what the allegations are. I see I'm over my time.
Any further questions?
I just have one. If the TCPA doesn't apply at all, then all that we've just been discussing goes away. And your friend on the other side argues that the bodily injury and commercial speech exceptions are additional reasons why her argument for non-applicability ought to prevail. If those are just new arguments in favor of an issue that was already raised, should we consider them? And if so, what's the answer?
Three answers. Number one, no, they were not pleaded. They were not raised until the Supreme Court to the petition for review.
Yeah, but if they're just new arguments, you don't have to, right?
You're probably right, but we can go ahead and say bodily injury doesn't apply because she is not claiming damage to the physical structure of her body. She's only claiming emotional distress, humiliation, et cetera, et cetera. Commercial speech exception does not apply because there is no allegation that whatever happened that day, which we say never happened, arose from the sale of goods. It arose from an alleged theft of goods. So it's...
Should we remand, though, for the Court of Appeals to address that in the first instance instead of doing so ourselves?
In terms of bodily injury and commercial speech, I mean, it's a possibility, but I think it's very obvious. Those were not raised by the Court of Appeals in its opinion. They weren't mentioned by the trial court. They weren't mentioned till here. So there's a waiver issue, and there's also an issue of is there any possibility in the world that they could apply based on these facts, and they just don't.
Any further questions? Thank you, counsel.
No, thank you.
We'll hear from the respondent.
May it please the court, Ms. Lewis will present argument for the respondent.
May it please the court, good afternoon. Ms. McKenzie was an innocent woman. She innocently went into Walgreens and tried to make purchases as a consumer. And she was faced with being humiliated, being called a thief, and doing absolutely nothing wrong. Walgreens is now asking.
That's my, okay, so you have these allegations and these facts and the claims that you've asserted, and in the trial court, the defendant files a motion to dismiss under the TCPA.
Yes.
And you argue TCPA doesn't apply because this was conduct and not speech. And trial court apparently agrees with you and denies the motion to dismiss. They go to the Court of Appeals, and the Court of Appeals reverses as to two of your claims, negligence and intentional infliction, and holds TCPA does apply to those claims, and you didn't put on a prima facie case, so those claims should be dismissed. And I read in your brief, and I hear you getting ready to argue, that was wrong. but you never filed a petition for review. You haven't challenged the Court of Appeals holdings as to those points. I mean, are you here arguing that your negligence and intentional infliction claims should survive?
Your Honor, not necessarily.
Right, you're just
I-
arguing that the negligent hiring claim should survive.
That's, yes, Your
So
Honor.
it
that's-
doesn't,
that's our
so
purpose.
you've conceded, for purposes of where we are now, TCPA applies, and you didn't put on a prima facie case of negligence or intentional, applies to negligence and intention. TCPA applies as to negligence and intentional infliction, and you didn't put on a prima facie case of those.
I
You've
don't agree.
conceded that.
I don't agree with, I do
But
not agree.
you didn't file a petition for review to challenge the Court of Appeals holding on that.
Well, Your Honor,
You haven't
that
challenged
it's not,
that.
it's in the, I can explain why. It's not a primary issue for this case, given the remaining claims.
Sure, so instead what you're saying is, look, even assuming TCPA applies to those two claims, and we didn't put on a prima facie case and they have to be dismissed, TCPA does not apply to negligent hiring, because that's conduct, not speech, and there's no basis to dismiss that under the TCPA, which is what the Court of Appeals held. You agree with the Court of Appeals, which is why you didn't petition for review on that point.
Yes, Your Honor.
Okay.
That does.
So we have nothing to
simplify it.
argue about whether the TCPA applies to the first two claims.
I'm not making that argument today.
Okay,
That is
then
true.
what they're arguing is, okay, even assuming negligent hiring is conduct, not speech, and therefore TCPA doesn't apply, even assuming that, you can't win on negligent hiring if you've already lost on negligence of the employee. Why is
don't
that
agree.
wrong?
Well, Your Honor, actually, I think the cases make it clear that you have to have an actionable underlying tort in order for the negligent hiring.
And you don't have one because it's been dismissed and you haven't sought review.
I believe that is inaccurate, that we do have an underlying tort. And as I stated in the brief, that your underlying torts, and also as the 14th Court of Appeal also found, the underlying tort here consists, it can be many things, and it was pled in the complaint as it relates to the facts. And as this court is fully aware, that you don't have to have labels as to the claims that you're alleging.
So
And-
this is, just to be sure I understand, this is your argument that there are facts that would support defamation and false imprisonment, and that those are the underlying torts for purposes of the negligent hiring, training, or supervision claim?
Yes, among other torts. For example, the Deceptive Trade Practices Act would apply based on the facts here, and also a claim
But did
under
you
42.
Did you plead any of those underlying torts, defamation, false imprisonment?
Based on the facts of the complaint, absolutely. And based on the claims, the facts in the case, they support a 42 U.S.C. 1981 discrimination claim as well. These are facts that are clear on the complaint, as well as in response to the motion to dismiss, which was the declaration by Mrs. McKenzie. I think that it's important that we go back and remember that this court has made clear that labels aren't required, and we know that because it would upend the Chapter 74 if labels were required.
Right,
So
but
we
if
have-
you have the elements of defamation,
Yes,
okay.
we have those elements. We also have the elements for the 42 U.S.C. 1981. We also have the elements for DTPA as well, pled in.
And in response
By
to
facts.
the response to the motion to dismiss under the TCPA, did you argue, we have a claim for defamation, we have a claim for discrimination, and those would support the negligent hiring claim?
I don't know if I specifically stated those particular claims, but I did not concede, and we do continue to allege that these are the underlying torts required.
Right, but the TCPA requires not just the pleading, but clear and specific evidence to support a particular claim.
And we have that.
Okay.
Yes, we have that
And
through the
you
declaration.
did argue, right, and I mean, the motion practice is a little strange in the trial court here, but because the motion to dismiss under the TCPA doesn't specifically mention negligent hiring, training, or supervision. It just says all claims. But in response, you did say that there was clear and specific evidence of negligent hiring, training, and supervision, and then they responded to that. So it seems like all that was before the trial court. Would you agree with that?
I believe it was, yes, Your Honor.
And so we have some other situations in the law where there are certain kinds of torts that depend on underlying tortious conduct. For example, like tortious interference with prospective contractual relations is one. What have we said, if anything, that would help us in those other areas about whether you have to plead the underlying tortious conduct as a separate tort, or whether you just have to plead the facts that would show there is underlying tortious conduct in order for your pleading of the overarching tort that requires the underlying tortious conduct to be sufficient?
Well, Your Honor, based on the requirements of negligent hiring and training and supervision, it says that you just need to show that there's an underlying tort. So I think just pleading the facts to support any underlying tort should be sufficient, especially given where we are now with the case law that's available and that was available at the time. Due process will require that that be the limits on whether the actionable tort is just supported by the facts and not going so far as to show the actual torts themselves. As long as there are underlying torts, I think that is the actual element that we have to meet for negligent hiring, training, and supervision.
So it would be your position that if you have a client that was injured in a truck accident, you could sue the trucking company for negligent hiring, training, and supervision and never have to plead that the truck driver was negligent?
Well, I think that's a little bit tricky because I think you would have to plead facts to support an underlying tort, whether it be the driver's negligence.
So if you plead that the trucker was going too fast and texting on his phone and therefore caused the accident, that's enough? You don't have to allege a negligence claim?
No, I don't think you do. And if I can give you an example, for example, the underlying driver, maybe they play games, and it's okay with the company for them to play games, and that could be considered an intentional act as opposed to a negligent act. And so that would still meet the element of a tort, an actionable tort, versus
even though you're not asserting a negligence claim against the driver directly, you're just pleading that he was negligent, and is that?
Yes, exactly, or whatever other actionable tort that would suffice. I think that we can't.
Because the employer is already going to be liable in respondeat superior for the torts of the employee, what worthwhile work is an independent tort of negligent hiring and supervision doing for us?
Well, I believe that it's an independent tort versus the respondent superior, which would rely specifically on the tort fee, the employee's action more specifically. I think the way the 14th.
My question is, how is it any different from just saying the employee committed a tort and you as the employer are liable for it under ancient principles of common law? Why do we need to have this label, negligent hiring and supervision?
That's a good question, but I think just to make sure that we do cover it all, that this claim was brought under both, and I think that it actually is codified, or there's case law that actually lays out the elements of negligent training, supervision, and hiring. Especially in regards to an underlying tort element, the actionable tort element. It actually spells out, which respondent superior doesn't spell that out as far as the elements are concerned.
It seems to me like, at least recently, every time we, in one of our opinions, even mention negligent hiring, training, or supervision, we include that caveat language about this court has never decided whether to recognize these claims under Texas law. But if we did, here's the elements, right? I mean, you've seen
Yes.
those cases, and so there is this open question about whether these claims are even viable, although I don't think the petitioner here's raised it. But it seems to me the issue is, could an employer be liable for negligent hiring, training, or supervision if the injury is caused by the employee not in course and scope, right? So in other words, say the policy manual doesn't, or negligently fails to ensure that the employee does not do something when they're off duty that could cause an injury. And that's where there'd be some relevance to this kind of claim.
I think that is
But in this case, it's really not that relevant, because if the employee is liable for defamation within the course and scope, then you have respondeat superior.
Yes. And I believe that is something that can be trained against as well, as it relates to the negligent training and supervision. The concern that I have about this case is the constitutional issues that it raises. The constitutional issues that bother me about this is that Walgreens is asking for constitutional rights, piggybacking off of an unidentified employee that they are not even agreeing exists, and applying the TCPA as a result, making Mrs. McKenzie's constitutional rights inferior to Walgreens at the end of all this. She should have the ability to exercise her right to petition when she's faced with the issue that she was faced with, being an innocent person walking into Walgreens that day. In addition to the Seventh Amendment constitutional provisions that are available to her to have a right to have a jury to decide the facts on these issues. But Walgreens is trying to expand the TCPA to allow an entity to piggyback off of this faceless, nameless person's alleged rights. And I think that's a huge issue that
Is their argument more that they can't identify that this took place in their store? They deny that it did. And instead of sort of these constitutional concerns, they just say, it's their position that, this did not happen in the way that it was later reported to the police.
Yes, Your Honor, and that's the troubling part, that you don't want to admit, as an entity, that these actions ever even occurred. Yet, at the same time, piggyback off of this mysterious, in their eyes, a mysterious employee's First Amendment right, and make it superior to Ms. McKenzie's rights.
Right, but your client came back and said it did happen, and here's how it happened. So
Right.
she brought forward evidence to
Yes.
contest that it didn't happen.
Exactly.
So in furtherance of her right to seek this claim.
Yes.
So I don't know where we are now, because it didn't look like the Court of Appeals or anyone's arguing that the case should be dismissed because it didn't happen.
Right.
Because there is evidence that it happened from your client.
Yes, and again, that is the troubling part, that they've not disputed that. They just said we don't know anything about it, we don't know who this employee is, but they've put forth no evidence that it never happened. On the initial motion to dismiss, there was nothing to dispute that has occurred. And so here we have a truly injured party who says, basically we're at a point where it says, yes, we know this happened. This was the police were called. We don't have any disputing evidence to that. They found, according to her facts, they found that she was not the person that was accused, and that she was apologized to by the police officer.
Why didn't you file a cross petition for review challenging the Court of Appeals conclusion that your client didn't put on any prima facie evidence to survive?
For the negligence claims.
Yeah, but why didn't you, negligence and intentional infliction, why did you just accept that?
Well, Your Honor, again, I go back to, I believe that we have strong claims remaining. If we look at the underlying claims, and we talk about the defamation claim that the 14th Court of Appeals identified in the facts, those, I think that my friend on the other side stated that, that those claims should not be, are not actionable. But I think that there was a prima facie showing that based on the declaration by Ms. McKenzie, there was defamation. And I do understand that there's this argument that it would have been outside of the statute of limitations because there's a 1-year statute of limitations for defamation. But there's also, this was something that was not argued in the lower court at all, the trial court at all. But beyond that, that is an affirmative defense that was not raised either. And if it were raised, that is something that would have to be addressed at the trial court level, not at this level. So I just want to address that aspect of the briefing as it relates to the defamation claim, which is still would be considered a viable, actionable tort, which we have put on prima facie evidence that would overcome the Texas Citizens Participation Act.
Counselor, the same question that I had for your friend in opposition, I'd like to make sure that Ms. McKenzie is heard here. So on page 11 of your brief, you say that after committing the tort, the Walgreens employee then called the police. Can you tell me what is in the live petition in this case about the order in which these things are alleged to have happened at Walgreens? Did the Walgreens employee humiliate Ms. McKenzie in front of members of her community before the police were called or after? And can you tell me what the live pleading says about that?
The live pleading does not set it out as a timeline. In a timeline fashion, it does state that fact, and in response, in showing the prima facie evidence, it was detailed in the declaration itself, and set forth that it did occur before the calling of the police.
And could you just tell me what is alleged there or what's in that declaration?
Yes. Give me just one moment.
Just because this representation is in your brief, and so.
Yes. I apologize. Should have that ready. That would be on page 1 of the declaration. And it's only a 2-page, but I believe it starts on the 3rd paragraph. I'm sorry, the 2nd paragraph. And it states that the Walgreens employee had made statements that I had been stealing from the store earlier in that day and on a prior occasion when she had never stolen anything. And after initial shock of the outrageous accusations being made against me, I immediately began to suffer humiliation, anxiety, and shame. Other patrons of Walgreens began to stare in judgment at me and make me feel uncomfortable and unwelcome. The Walgreens employee made this statement, which was hurtful and defamatory. And then it goes on.
It says in the 4th paragraph, I was advised that after the Walgreens employee made the statements, Walgreens personnel began to investigate. And then 3 paragraphs later, it says, I was further subjected to humiliation after being approached and questioned by the police.
Yes, so the further outlines, thank you.
Thank you. Thank you.
Just so are you saying that establishes the timeline that the statements were made before the police were called?
Yes, it clearly states, establishes that timeline. Not the best that I would have loved to, but it does show that it was an after event from the initial accusations.
Thank you.
Any further questions? Thank you,
I-
Ms. Lewis.
Yes, and I would just ask that this court hold that Ms. McKenzie's rights were violated, and she is entitled to her own constitutional rights as well, and that the trial court and the appellate court, the 14th Court of Appeals case should be affirmed. Thank you.
Thank you, Ms. Lewis. Mr. Griffiths, I believe you have 5 minutes.
Thank you. 4 quick things, piggybacking pleadings, and then I'd like to circle back to Justice Busby's question because I feel your dissatisfaction with my answer. Piggybacking, yes, we're piggybacking because respondent superior allegations were made. It's not the mysterious employee that's being sued, it's Walgreens, the employee that's being sued. So yes, a corporation can only speak through its employees. Pleadings, I just revert back to Rule 45 and 47 that say, it doesn't say you can just plead facts and then make the other side ferret out your causes of action.
So what's your best case for when you've got a tort that requires underlying tortious conduct, that you have to plead the underlying tort itself rather than pleading that it happened? So in Justice Boyd's hypothetical, why do you have to sue the truck driver for negligence and assert a separate negligence claim against the truck driver in order to assert a negligent hiring claim against the trucking company, and just plead just plead that the driver was negligent?
You can do that.
Okay.
You can certainly do that. But again, we're in the TCPA stage here, and again, it becomes, we have to focus on the legal action. The legal action is negligent hiring, training, supervision. What has to be proven with that legal action is an underlying employee tort. So you still.
But what she's arguing is, okay, maybe I didn't plead and provide sufficient evidence of negligence or intentional infliction, but I pled other misconduct by this employee that was foreseeable and supports the negligent hiring claim, that I pled enough facts about misconduct by this employee that my hiring claim should survive even if the other two don't.
I may not be answering this correctly, but I think, and tell me if I'm not, but again, there was no argument. I mean, the Court of Appeals said whatever the employee did, it was protected conduct. We know that. So then it becomes, at that point, the negligent hiring claim should have been put on the shelf until such time as she came forward with prima facie evidence that the employee had actually committed an actionable tort. Does that answer your question?
Well, yes and no. I mean, as to the negligence and intentional infliction, yes. But what we're getting at is, should the law require her to plead and prove an actionable tort against the employee in order to support the derivative claim against the employer?
Oh, absolutely.
Or is it enough to merely plead and provide prima facie evidence, if necessary, of facts of misconduct by the employee without regard to whatever tort or other wrongful or other legal claim that misconduct may support?
I don't think you can do it that way.
I mean, we said back in Waynesy, the Texas courts, there's a broad consensus among Texas courts that such a claim, a negligent hiring claim, requires that the plaintiff suffer some damages from the foreseeable misconduct of the employee. So is it not enough to just plead facts of misconduct by the employee, as opposed to having to actually plead a claim against the employee?
Well, in the pleading context, yes. I mean, your court has said that the pleadings are, I forget the exact word, the best and all sufficient evidence or framework for the particular claim. So I think you have to do that. Otherwise, Rule 45 and Rule 47 get turned on their ear, because now we can just plead facts and not plead causes of action.
Right.
It'd be hard to have an argument about whether the elements of the cause of action have been made, that there's been a prima facie showing as of the elements of the cause of action when you don't know which cause of action you're shooting at.
Well, but the cause of action is negligent hiring. So could she have sued only Walgreens here and sued you only for negligent hiring and pled misconduct by the employee that was foreseeable and the result of the negligent hiring and supervision and proximately caused damages without ever asserting that the employee was negligent or defamed her or any particular legal cause of action against the employee?
No.
All she had to plead was negligent hiring and training.
No, you would have to plead and eventually prove an underlying tort. Otherwise, then it just becomes a cause of action for negligent hiring without there being an underlying tort.
But if the facts that are pleaded are false imprisonment or defamation, assuming they're true, then haven't you done that? Even though you haven't labeled it as a separate defamation claim against the employee, if you plead facts that, if they're true, are defamation or false imprisonment, isn't that enough?
I don't think so. But then over and above that, if we do decide to engraft these additional causes of action based on factual allegations made in the declaration, okay, I don't think that's right, but if you choose to do that, isn't it also okay to say that an anti-SLAPP motion that specifically says we are attacking each and every cause of action alleged by her based on protected conduct? I mean, in fairness, shouldn't that be sufficient?
I can't tell whether this is hypothetical or not. Your friend in opposition has suggested that there was a violation of 42 USC 1981. We can imagine reasons why she might not have wanted to plead that claim. It would have been a federal question claim, then we might have ended up in federal court, and then we wouldn't have this excuse to be here at Baylor Law talking with you today. But suppose that the allegations in the complaint are an employee of Walgreens called the police and said, I do not wish to engage in a contractual relationship with Miss McKenzie because she is an African American, so a textbook violation of 42 USC 1981. Doesn't plead that claim, but says the fact that Walgreens has hired, trained, and supervised somebody that engages in that reprehensible conduct, that's what was negligent here. Are you saying that if that were the only allegation here, that she would have to plead a 42 USC 1981 claim that would allow your client to remove to federal court? Or can she just come into state court and say, this is a negligent hiring, training, and supervision claim?
I think I finally get it, what you're asking. No, it's established law, back to Byrd, back to Wanzi, to prove negligent hiring, you must plead and prove underlying actionable employee conduct. So, yes, there would have to be a pleading.
But there's a difference between conduct and a claim. So if she did not wish to seek the remedies that would be available to her under federal law, but could plead and prove that purely hypothetical thing that a Walgreens employee said, if she did that, is it your position that Texas law would or would not allow for a negligent hiring claim?
It would not allow for a negligent hiring claim. I'm way over.
Any further questions?
Thank you all.
Thank you, counsel. The case is submitted. The court will be back in a few minutes to visit with you, but for now, the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.
Well, thank you all again for being here. We've lost some of our audience, but listen, we had a much larger and more attentive and more engaged audience here this morning than we typically have in our courtroom in Austin. And we really appreciate your hospitality and your attention to these arguments. We're glad you were here and happy to take questions and have a conversation with you about what we just saw or about any questions that you have at all about the court.
Thank you. My name is Bonnie Worstel. I'm a 1L here at Baylor Law. So a lot of my classmates and I are having our first moot court exercises next week, which we're really excited about, obviously, maybe a little bit nervous. And so I was wondering if you could share any advice that you have about being an effective advocate for an appellate court, just as your perspective on judges. And then whether you have any general do's or don'ts for us that you see maybe come into your courtroom that you're like, this is a really good way to do things, or this is a terrible way to do things, don't do this. So would really appreciate that insight from you all.
Justice Young?
I think that the best thing that you can do in arguing before an appellate court is to pretend like you're an appellate judge beforehand. Think what it is that you would really want to know. What are the hardest points? If you can know your opponent's case better than your case, that's good because you'll know what the weak spots are. You prepare for them, anticipate the questions, and answer as directly and clearly as you possibly can. Have a nice conversation with us. You know, stop talking when one of us starts talking, but it's a nice conversation with that one caveat, and it'll feel like a great experience.
Any thoughts, Justice Sullivan?
As the most recent to make the switch over to this side, I would say try to have empathy for the audience that you're talking to and what you're trying to persuade them to do on behalf of your client. Remember that, you know, especially when you're a new lawyer or when you're doing moot court, you have one matter to get ready for. And the people sitting on this side with the black dresses on have a lot of things that they're having to think about. One thing that I always looked for when I was at the podium was what are the things that folks are writing down? I mean, our arguments are recorded, which is a great resource to bench and bar and to law students. And so we can always go back and see, they said that it was at paragraph 2 and at paragraph 4. But if you can be outside of your own head enough to be watching your audience and see, oh, they were writing that down. And what were they writing down or what were they leaning in for when your friend in opposition is up there too? Those are the things that this is your opportunity, you know, legally and ethically to share things with us that will help us, you know, do the work that we've taken an oath to do.
I'm going to say in your case, you've already got good eye contact and engagement. Speak louder. Some of us are getting a little older.
I'll add to that in terms of what you might do at home. It's prepare, and good way to do that is to do it out loud, in your mirror, with a friend, so that when you take the podium, this is not the first time you hear yourself going through the argument. So video record yourself, ask for feedback, and so that when you're here, you feel nimble and you feel like you're able to not just recite your presentation, but really listen to what the court wants to know about and really drill down on the issues that they are focused on. So prepare, but then also prepare to abandon your preparation, your presentation.
Yeah, also keep in mind that the opinions that we will issue will apply to a broader, to everybody in the state of Texas. And maybe the facts are a little different and help us out in making sure that when we come up with our opinion or the reasoning that you will help us prepare for that and keep that in mind.
And don't get thrown off by it.
Yeah.
Because sometimes we'll ask questions that really don't have much to do with your particular case. But again, like Justice Devine said, we're deciding cases that are going to apply across the board, and we have to be very careful about that, so don't let it throw you off.
And when you're preparing too, I think it's great to have sort of notes of the main points you want to make, but don't script it out. Don't write out like every word you're going to say, because you're never going to get to say it that way if you've got an active bench, which most of the time, hopefully, you'll have. And really, that's what you want as an advocate once you're out in practice, is the questions, because you've already had a chance to file a brief, and we have all of the written arguments. And so what you hope you get as an advocate is the questions from the court, where maybe they're having trouble understanding and getting to to where you are on something, and we're saying, I'm having trouble, can you help me with this? And even if we're not presenting it in that way, that's mostly what judges are asking for when they're asking questions, is how can you help me understand your argument so that you win? And so those questions are really a gift. And sometimes, as Justice Lehrman said, they're not exactly relevant to your case, but to what the holding may look like. And so if you've got your outline written out in such a way that you can answer those questions and then sort of smoothly get back to the next point you wanted to make that you haven't gotten to yet on your outline, and hopefully it's on one page or two facing pages so you're not having to turn back and forth, it can be really fluid, and the best advocates are really good at doing that and transitioning from the answer to a question to their next point.
Thank you for the question. This is anybody's chance to come ask us the questions. We were asking all the questions. We were driving the show earlier, and this is your chance to ask us anything you'd like to. Go ahead.
Thank you, Mr. Chief Justice and honorable justices. My name is Christy Lopez. Thank you so much for being here today. This is such a fantastic opportunity. I know a lot of us are probably interested in becoming a judge at some point in our careers. I wanted to ask you if you have any advice for that path to judgeship and going from law student to lawyer to judge.
Justice Bland?
So there's a lot of ways to put yourself on a path to becoming a judge. And you can practice a lot of different kinds of law. You can be engaged in a lot of different kinds of activities. What I would say is, especially as a very young lawyer, to take on any challenge so that you can really cultivate a broad skill set, so that as these options for different career paths come your way, you can make an informed decision about what is right for you and your circumstances. And you'll have that bottom line skill set that would make you good at whatever the next step in the path is. So the steps can look different for different people, but you have to be excellent at being a lawyer in one way or another. And the way to do that at the very outset is to cultivate as many legal skills as you can. And then from then on, you can engage in activities that you think might help you become a judge. But I don't think like there's you graduate from law school and there's not a preordained path to becoming a judge.
Thank you.
Yeah, I agree with Justice Bland. I would also add, don't ever take any job for the next job, because you won't do the job and the work that is in front of you at the level that it will take to develop the skills that Justice Bland said that you need, and attack it with the vigor you're going to need to do it. And then find things that you care enough about and work with people who are going to get the best out of you, who are going to mentor you, and don't go to a firm or a DA's office or OAG or a nonprofit or any of these things because someday I'm going to be a judge. Instead, work with good people and do the work that's ahead of you, show the excellence like Justice Bland talked about, and then it can probably work out, and then you too can take a pay cut someday.
But also I would add that and it may not work out. There are a lot of people who want to become judges who really aren't ever able to become judges. I have a lot of friends like that. And so, like both of the prior justices have said, do your very best at whatever you're doing, and hopefully do something that you enjoy, because it's going to enable you to do it better. And then realize that if it doesn't work out that way, then that's fine too, and you can enjoy your professional life in spite of the fact that that may not turn out.
Or,
go ahead.
When I was in law school, I had no intention of being a judge. I really didn't have any intention of practicing law. I came out of the corporate world. And I wanted a law degree just for the sake of having a law degree. And so here, 25 years later, I wind up on the Texas Supreme Court. So even for those students who may be not thinking of that right now, it's still possible to live out your dream. And you certainly, you have to go through the political world in Texas. As you know, judges are elected. They can first be appointed, but then you still have to run for elections, which is a political element, which sometimes you don't fully appreciate until you're in the middle of that suit. But
Thank you.
I'll add one thing to that, which is that's all right. When I was thinking about going to law school, I never knew a lawyer. I didn't have any lawyers in the family, but a friend of mine, a guy at church was a lawyer. I said, "Can we go to lunch?" I think about going to law school. And he said, "Why do you want to go to law school?" And I said, "Well, I think I'd want to be a judge someday." And he said, "Jeff, you do not go to law school to be a judge. You don't start practicing law to be a judge. Put that out of your mind. Go if you want to go to law school and be a lawyer, great, but then look for opportunities." So I think I'd been practicing like 6 years, and a local Travis County district judge announced he was retiring. And someone else who was very active, Travis County is very blue, and someone very active in the Democratic Party said, to me, "You're pretty conservative, aren't you? Why don't you apply for this judgeship? Because Bush was governor, and he's going to appoint someone conservative, and we think we could live with you," is what this Democratic friend said, which I learned later meant we can live with you until the election when we, vote your rear out. But, and so that got me thinking about it. Well, I thought, well, I need guidance. I need advice. And I had gotten to know John Cornyn, who was then on this court, through the local Inns of Court. And I just called him out of the blue, and I said, "Justice Cornyn, this is what I've been told. What do you think?" And he said, "Well, I'll tell you what I think. Number one, if you apply, you're not going to get it, because just the nature of politics, a middle-aged white male is not who Governor Bush is probably looking for a Travis County bench." He said, "If I'm wrong about that, number two, and you get appointed, you're going to work really hard and lose the election. But number three, absolutely apply." That's what he said. And so I did. I applied, and Justice Sullivan just joined us after serving as kind of the governor's point person on helping the governor select who to appoint for judges. So he can tell you more about that than I can, especially under the current governor. But I applied, I went over, I interviewed. Governor Bush appointed a friend of mine, Ernest Garcia, to the bench, so number one was right. Ernest he was a good judge, and he ran really hard as a Republican and lost in Travis County, so he was right on that. And about a year and a half later, then General John Cornyn called and said, "I need a deputy attorney general for civil litigation, and I remember that you're interested in public service. Would you come talk to me about that?" So you never know. It just, but the lesson I learned from that is at some point when you're down there working hard as a lawyer, wherever you may be, some opportunity is going to come up, and don't be afraid to let people know you're interested in public service. And by doing that, people will know, and then you never know what doors that will open. So I think they're right. You got to keep your head down and work hard and be a problem solver at whatever you're doing, for other people to have the confidence in you to then give you the opportunity to do the next thing.
Thank you so much.
Yes, sir.
Hi, I just want to thank y'all, first of all, for this opportunity. My name is Evan Patel. I just started here like 2 weeks ago. Yeah, this is just an incredible opportunity to kind of see the law, actually being played out at my school. And I just wanted to ask y'all, what was it that led y'all to go from law to judge? I know this is kind of similar-esque question to the previous one, but instead of being a lawyer, why did each of y'all go, take the role of judge? And I think specifically also I'd like to know why the Supreme Court of Texas, not like a federal court. What was it about this court that was really appealing to y'all?
Well, I'm calling someone who's made that move a couple of times, Justice Huddle.
For me, sort of very big picture, I'll start with the big picture and not the mechanics of how it happened, but the big picture was that I felt like, even before I started law school, a sort of calling to do something with my skill set, with my mind, that would contribute to sort of the greater good in the public, right? And so for a while, I thought that might look like public interest law. It turned out that that kind of job would not have earned me enough money to retire my law school debt, so I decided against going straight into public interest law, and I worked in private practice for many years. During that tenure, a couple of different things happened. One is I got a lot of experience very fast, and so I learned a lot in what feels now like a pretty short amount of time. And in that process, by sort of getting to know people farther ahead of me on their career trajectories, I started to learn what the skill set, what the life of judges looked like. And so I had many colleagues who had gone on to the bench. Justice Bland, for example, left the law firm where I practiced right before I got there, and so she was someone sort of in my orbit, and as were a number of folks. And so I started to see over time that I really liked the skill set. I really liked thinking I could see myself being a neutral, right, and deciding and adjudicating questions and really thinking deeply about the issues as opposed to being an advocate, although I really loved that too. And so that was the big picture, is how can I sort of give back, right, sort of a little, it sounds grandiose, but that was at the root of it. And then also, as I became more experienced, I realized that is something I would actually love to do. Being an appellate judge is very different. How you spend your day is very different from how you spend your day as an advocate. I really grew up a trial lawyer and not an appellate lawyer, and so in my day-to-day life, I didn't have hours and hours to think or write on a particular legal issue, and so it turns out that I really love being able to do this for big chunks of time. So it's slow, and I just would emphasize the importance of making the ask of people who are in sort of that orbit. How did this happen for you? What should I be doing to prepare myself in case lightning strikes and that opportunity arises for me?
And you asked about the difference between federal court and this court, and you're being on either of those courts, and that goes back to what we were talking about earlier, which is that the way our system works, and appropriately so, the judges don't decide which court they serve on. The judges don't decide whether they get to be a judge. The president makes that decision, the governor makes that decision in some instances, the people of Texas make that decision. It's never ultimately up to you, whether you are a judge, and if you are a judge, which court you serve on. And so that goes back to what Justice Lehrman was saying and what others were saying. All you can control is that you work hard and give your very best at what's in front of you in whatever capacity you're in. And if over time you develop the kind of reputation that people look at you and think, this guy might be a good judge, then that may happen for you or it may not, but it's not it's not something that goes to the person who is the most ambitious or works the hardest for it. It's something that sort of happens to you in a way. And in that way, it's not a goal you can put in front of yourself, like, oh, I want to start my own firm, or I want to practice this kind of law, or I want to do this, or you're not ultimately in control of whether you end up as a judge. And but you are in control of how hard you work and the things that you do that influence other people's perceptions of you and that build your reputation for integrity and excellence over the years. And so that's, I think, what you're hearing from all of us, is that's what you can control, and that's what you should be striving for if you have in mind that you might like to be a judge someday.
I agree with the chief, that it'll be something that you'd be called to do. You had asked about specific courts, and I can tell you, as the chief mentioned, my former client, I was lucky to counsel Governor Abbott on, I think he's now appointed 6 members of this court, including me, and so 5 out of 6 ain't bad. Did very well on those. And I was also fortunate enough in my practice, mostly my time in public service, to have also gotten to know Justice Lehrman and Justice Boyd and Justice Devine. And so one of the things that was very exciting to me about coming to this court is this is a collegial court, and I knew that I would have 8 outstanding and amazing colleagues, and I was right about that, and so I felt very fortunate to have been called to be in this place at this time. So, but as the chief said, you don't get to, there's not an order for him to say, I will simply be on, the Supreme Court of the United States and that sort of thing, but do your best, work hard, treat people well.
I'll share a story because he's brought it up. But before I served on this court, I served on the Intermediate Court of Appeals, the First Court of Appeals in Houston. And part of the process for getting on this court was going to an interview at the Capitol, in which now Justice Sullivan grilled me probably for 20 minutes about various opinions I'd written while I was on that court. Be ready for that.
Opinions that maybe he did not agree with.
I would also add, no, it's not yours to offer the job, but there are aspects of your life that may dictate whether it's right for you at a particular time in your life. And so one of the things that you always have to think about when you're making professional decisions or career decisions is, how does this impact the rest of my life? So, and I encourage you not to shy away from that, because a well-rounded life includes, family, friends who are like family. Maybe some of you have children now. Maybe you'll have children someday. And just remember, a professional occupation is a role that you occupy. That's why it's an occupation for a time. And what you may think about that role is different at different times in your life. And so don't forget to save the best part of yourself for your family.
And also, you asked something about federal court versus state court, and at least from an appellate perspective on the state Supreme Court, I think that while we are, a lot of different factors, are at play as to whether or not we have the privilege of serving in this capacity, but once we are able to do that, the cases that we hear are extremely fascinating. We have discretionary review. We only grant review of cases that significantly affect the jurisprudence of the state of Texas. And so as opposed to, say, an Intermediate Court of Appeals, say the Fifth Circuit, at the federal level, they're mandatory review, just like our intermediate courts of appeals. So in a lot of ways, and I think if you talk to some of the people who have served on our court, like Don Willett or like Priscilla Richmond, they will tell you that the cases they heard here were much more fascinating, interesting than the cases that they heard on the federal level. But
She chose the 2 Baylor grads.
Right. Obviously, good choice, right? But there's other factors that come into play. For example, you once you're appointed to a federal bench, you don't have to run for election again. And so, there's some other factors that come in. But as far as the caliber of the work, it's really fascinating where we are.
Can I just add, you asked what it is that led us to the path, and for me, clerkships was a big part of it. I clerked for 2 really great judges, and that put in my heart the idea that seeing the way that they served the people with such integrity and diligence, that if that was really something they could devote their lives to, it was something that if the opportunity came, I would be honored to do it as well, and that really opened my eyes to it. Clerking is a great thing, not just for future judges, but for future lawyers. And there are a lot of courts in Texas where you can clerk, a lot of courts across the United States where you can. So I'd encourage any of you who are interested particularly, but not only, in a litigating future, to consider a clerkship at a trial court or an appellate court in order to really see on the other side of the bench what it is that motivates judges and how decisions are reached, what it is that counts as a successful argument versus one that doesn't quite work, and why. And that's an enriching experience that will serve you and your clients very well for the rest of your lives, whether you actually become a judge or not.
And we do need more Baylor Law clerks. The only one on the court this year I was fortunate to inherit from Chief Justice Hecht, but your ceremonial marshal today, Courtney Sorrell, is a graduate of this fine law school. And thank you for keeping us safe today, Courtney.
All right, thank you. I believe we're probably overdue for lunch. Did we have just one more quick question, maybe?
Thank you so much for being here, and to the law school for providing this opportunity. I'm not a lawyer. I'm a PhD student in material science. I know nothing about the law. I figured out like a couple minutes ago that the first person listed in the case name is the plaintiff. I was really confused. So I guess my question
It's
for
actually
me.
more complicated.
It's
Yeah, I know you're wrong, but that's okay.
Back to the lab.
So I have to vote for you all. I have to vote for judges in the state of Texas. Me, my engineering buddies, a bunch of non-lawyers. I'm wondering what you all would want us to consider when we vote for judges, like in the primary and in the general, there's the party, but especially in the primary and earlier. Like, what should I be looking for? What should my friends be looking for when we decide who the judges are? And don't just say incumbency, because like, that's.
Well, we'll say whatever we want. Anybody want to take that?
I think that's a great question.
It is.
And I wish that
Yeah.
more people across our state really asked that question, because it wasn't always the case that in Texas, judges were elected. It started off where the president of Texas and then eventually the governor of Texas would nominate and the Senate would confirm for a period of years the judges. And then it came to the legislature's notice that maybe they weren't making the best choices, and perhaps the people in each community would know who was the most responsible, who was sober, who had good judgment, who was kind and responsive, and the kind of person that could exercise this massive authority over the citizens. And they said, well, it'll be the people in the community. Let's let them choose. They didn't anticipate that we would eventually have counties where we would need hundreds of judges, and nobody can know everybody can know a judge. And there are parts of our state where there's a judge, basically. And you can know that person and basically have the same kind of information that our ancestors did 150, 200 years ago. But for the most part, it's very difficult, even for lawyers, let alone mechanical engineers, to know what it is that would distinguish this human being from that human being, which is going to be a better family law judge, which is going to be a better criminal court judge or an appellate judge. The way I think to find out is a number of things. First, find people that you trust that really do know, that are deeply in practice, and that you believe they're going to give you advice, not just based on if it's their friend or something like that, but based on their deep experience with the courts. Second, all judges have to run in our state, and they're always happy to see people. So if you're in McLennan County and there is a primary election, a couple people would like to be your district judge, they'll have events and they would be thrilled if you come up and say to them, all right, tell me, how is it that you are going to be able to comply with the promise you just made, that I will not legislate from the bench. I'll apply the law as written and not as I wish that it had been written. Things like that. All judges and candidates for judge say that. But if they can explain how they can do it to your satisfaction by saying things like, for example, well, my job generally is to take a look at a piece of paper, maybe a lot of paper. Contracts can be hundreds of pages long. Statutes can be dozens of pages, or even sometimes hundreds if it's a whole code. Do they have the skill to even understand the obligation to be able to figure out what those words and the relevant text meant to the people that they were written for at the time that they were written, and to be able to then say, my job is to figure out what that was 100 years ago, if it was a statute or a contract or a deed or something like that that was written 100 years ago, to figure out what those words meant to ordinary speakers of English, and then to be able to say whether I like it or not, that's what the law is, and I'm gonna apply it. And if they can't even answer that question, then maybe you move on to the next candidate. But if they can honestly give you a sense that they are committed to the idea that judges are different from the other two branches of government, that our job is oftentimes, Justice Lehrman has said this many times, our job is not to like our rulings. Our oath instead is to make sure that they're the most accurate we can make them under what the law is. And that requires people who are experts in the construction of statutes and the interpretation of constitutional provisions. We probably shouldn't have judges who are 22, even if they're really smart, because it requires experience and judgment. And that's something that ordinary people can, if they're willing to invest the time, and particularly if you gather up with others and divide the load, you can actually make a difference in choosing people who don't just have nice last names. There are studies that show that if you have a name that has a color in your name, for example, that's a nice little bump in the polls. Or if your name is an ordinary Anglo-Saxon word like young, it's a little bump in the polls. What a terrible, I mean, I'll take whatever I can get, but I'd rather win the election based on the idea that.
How about divine?
Divine, I mean, come on, right? I mean, it would be better for us all if we knew that the people chose us because they really believe that we're able to discharge the oath that we take. But I'm afraid there are a lot of people who show up to the polls and don't really know. And sometimes they just decide not to vote in a judicial election. That's unfortunate, but it's even more unfortunate if they just say, well, that name sounds better, that's prettier, that's a male, I'll vote for him, or that's a female, I'll vote for her, without any other information. And so the people of Texas have more tools for self-government than any population in the history of planet Earth. That's what our ancestors gave us. The tools of self-government are massive in our state, including choosing people who will even exercise judicial power at the lowest levels of the judiciary. But if we don't use those tools wisely, we'll get what we deserve sooner or later. And we've been pretty lucky, honestly, in our state, despite often having voters who don't really go to the trouble and don't know how to go to the trouble if they wanted to. So I think it's a wonderful question, and I hope you'll keep thinking about that.
Can I add one thing?
Sure.
It's a brilliant question, by the way. So if you're pro-choice or pro-life, if you're pro-gun or pro-gun reform, if you're whatever, pick your issue, and it's time to go to the polls, and you do your research, your legislators, your executive branch officials, figure out if they're pro-choice, pro-life, pro-gun reform, whatever, and vote for the ones that represent the policy choices that matter to you. The hard part about judges is when all of you guys and your neighbors and your friends start seeing us as another way to promote your policy choice, whatever the issue is, which I think we're seeing more and more in the last 10, 20 years, the judiciary becoming, the public more and more considering the judiciary as just another political branch, undermines the entire role that our judicial system plays. So I can confidently say that 99 out of 100 judges I've ever known know better than that. They may have a policy choice, but when they put on the black robe, they know it doesn't matter. And what I really urge you guys to do, because I think it's so important for the future of our form of government, is find out if the judge is driven by policy choices, and if those policy preferences of that individual are going, and I don't care left or right, are going to determine how they judge, and vote them out, vote against them. Not because I'm for that or that, this or that policy choice, but because when the public starts treating the judiciary and the judiciary responds by becoming just another political branch, we've really undermined the rule of law in our country. And I think that's a real risk right now for the 20 years ahead of us.
Thank you. Great
thank
question.
you all.
Great questions from everybody. We appreciate your time. And as I said, it's an honor to have been here with you today. We're headed to lunch where I think we'll see a few of you. And God bless you all. Thanks again.
We are going to take some pictures.
All right.
But everyone is free to go. The court's going to stay for just a minute while we take some pictures. The photographer is here for us.